Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Torts class. In this class, we are going to discuss the topic of specific torts called as false imprisonment. Friends, already I told you these specific torts to person. They can be called as trespass to person and they can be initiated as a tort as well as a crime also. So, false imprisonment means, please remember, Blackstone, he said every imprisonment or every confinement of a person, maybe in a jail, maybe in a common prison, maybe in a private house, or maybe in a public street, it amounts to residuary trespass or false imprisonment. So if you stop any person to move from any place, that's why I have given the definition of force in my last video. Please remember, what is force? Already we have discussed it. Change of motion, cessation of motion, or transferring of a motion of a person according to section 349 of the Indian Penal Code. So, likewise, if you stop a person from moving further, if you stop a person and ask him to go in another direction, unlawfully, intentionally, that's why I call it as intentional tort. Yes, it will be amount to false imprisonment. In the Indian Penal Code language, we call it as a wrongful restraint or wrongful confinement. Wrongful restraint means, according to section 340 of the Indian Penal Code, whoever wrongfully restrains any person, whoever stops any person, is liable under section 340 because he is preventing him to proceed from other way. Number 2, if any person is confined, particularly in a room or something, it is amounting to wrongful confinement, which is punishable under section 342 of the Penal Code. Of course. So normally, if you file cases under IPC, you have to discuss more on this topic. In the Indian Penal Code session, the lecturers will tell you more about the same. For the present, so come back to the topic, false imprisonment. So confinement of a person for any time, maybe a minute also, it amounts to false imprisonment. It is against to Article 21. What does it say of the Constitution? It says the state has to protect the life and liberty of each individual. A liberty of every person should be protected. Now we'll come to the case laws. The first case law is Bird versus Jones, 1845. So actually, Mr. Jones, he has occupied a pathway and he has erected a gallery in order to make the people see the so-called boat race in the lake. So boat race was being conducted in the so-called pool. Outside, he has erected the gallery. Actually, he has encouraged the footpath and extended the gallery. So our friend Mr. Bird went there. He wanted to witness the boat race free of cost. Here, if you pay money, then only you can sit in the gallery. If you can't pay the money, then you have to go other side. So what happened is this man went there, he wanted to sit and enjoy the immediately Jones said, no, only persons who are paying the ticket fee, you are authorized. Then he said, you have already occupied the footpath pay, then why should I pay the money? And he started arguing with him. Ultimately, he has climbed a little bit of the gallery and he was witnessing the so-called boat race. Ultimately, he was forcibly dragged down and kept someplace. So therefore, he filed a case of false imprisonment. So he climbed up the fence to go upwards, but he was prevented by the defendant's agent. That is Jones' agent. So he filed a case of false imprisonment. But court held no. Why? Because there was no total restraint. He was only just dragged down. And the plaintiff could have easily taken another vehicle. Actually, Mr. Jones told him, you go to that corner and sit. But he said, I want to sit here. And he wanted to climb. So please remember, if you read my notes, it will be easy for you to understand. And second, please remember, positive example, me versus Cruikshank, 1902. So actually, the prisoner, Mr. Me, he was an under trial prisoner. Ultimately, the case against him ended in acquittal. Case అయిపోయింది. Then he has to be released. So before release, actually the order of release was signed by him, but before actually release him, the so-called Cruikshank, who was the warden, so this man asked a few questions by confining him in the cellar portion of the jail. Me was asked some questions. So normally questions will be, don't commit such type of things, we will shoot you, we will look after all these things. They will give some threatenings. The court held that it is a false imprisonment because time doesn't matter. That's why I told you, even 1 minute time is also false imprisonment. Time doesn't matter, but what matters is restraint of the liberty of the individual. This is more important. Now coming to yesterday's video also, I told you that I will tell in this false imprisonment. That is Herring versus Boyle, 1834. Herring versus Boyle. So here Boyle, the headmaster, he refused to send the boy along with the mother because the mother failed to pay the fee. If the mother is ready to pay the school fee, yes, he is ready to send this boy even in the interregnum period of the college, school జరిగే మధ్యలో పంపిస్తాడు. కానీ if she fails to pay the money, he will not release the boy. That is false imprisonment. But please remember, court held that no false imprisonment because it is the duty of the headmaster to collect the so-called fee. They are not giving free education at that particular point of time. It is 1834. He has done his duty. He asked the mother to pay the money. So he should give a threat. Otherwise, who will pay the money? So this way, please remember, it is a negative example. Now we'll come to the another case. John Lewis and Co. versus Timms, 1952. So Timms is the mother, and this mother along with her daughter, both of them went to the shopping mall John Lewis and Co. Incidentally, the daughter, she stole a purse and kept it dropped it in the mother's bag. The shelter, the security guard, he was so alert. He actually suspecting them, he confined them in a room and informed the police. The police came there, they inquired. Ultimately, they came to know that the daughter caused the so-called, he committed the theft and mother is innocent. So they left the mother and booked a case against the daughter. Now the mother, Timms, she filed a case against John Lewis and Co. And of course, in the appeal, you are studying the appeal case. So ultimately, finally, the court held that they have taken a reasonable time because why they have confined them? Because of the arrival of the police. Till the arrival of police, yes, definitely, they are authorized to detain them. So therefore, it's not false imprisonment. Then another important case, Heard versus Weardale Steel Coal and Mines, Steel Coal and Coke Limited, 1915. So here, what happened is Mr. Heard, he is a worker in the so-called Weardale Steel Coal and Coke Limited. So as usual, all the workers went to the coal field. In the downwards, the lift took them down. But during the work, he picked up a quarrel with the fellow employees and he wanted to come out. But the lift did not come. Lift came only at the specified time, that is 4 p.m. He was under the impression that he was imprisoned till 4 p.m. So he filed a case. But please remember, the court held that it is voluntary non-fit injuria. You know that the lift will come only at 4 p.m. You volunteered to do the work. And he has willingly entered the mine and the defendant was only obliged to take him at the particular time. So therefore, after the shift is over, it's not false imprisonment. So what are the remedies for false imprisonment if you are confined illegally? So number one, self-help means if there is any other route, escape route, happily you can go away. Nobody can file a case against you. Second is filing a habeas corpus petition. So habeas corpus means produce the person before the court. So Article 32, you will be knowing more. Action for damages. This is what's called tort law. And ultimately, parental authority. Sometimes you can imprison. That means you can ask your boy to stay in the house, not go outside. So you can use your authority. It cannot be false imprisonment. So with this, I am concluding. Hope you are now clear about the false imprisonment. Thank you very much.